Hi, David Campanile here, owner of Campanile Law, located in the state of New Jersey. We handle estate planning and probate. Before we dive into today's topic, which is going to be about insolvent estates versus solvent estates, if you have any questions pertaining to estate planning or probate, contact me at njestateattorney.com. You can send me an email at david@campanilelaw.com, or you can schedule directly on my calendar. There's a link below or a link above for you. So today's topic is really about how to compare insolvent versus solvent estates. So this week we've kind of touched a lot on probate. So just to give you the definition, a solvent estate is basically an estate that can afford the real and personal property of the estate is sufficient to pay the debts, which means that the assets in the estate are greater to or equal than the debts of the estate. So that's considered a solvent estate. Solvent estates are basically you've notified creditors, you're getting everything, all the any bills that are owed, anything that's owed to that the decedent had to pay, and then you have all the assets. You go to the surrogates court in the state of New Jersey, and you say, look, here are all the debts we have to pay. Here's how much money we have in the account. We can cover all of our expenses. The court will issue a court order, and you pay out your expenses. On the flip side, however, insolvent estates a little bit more tricky. So the definition of an insolvent estate is, and this is by the New Jersey Rules of Court, and I'm going to read it verbatim. The real and personal estate of the decedent is insufficient to pay debts. Now, what does that mean? It's kind of you can say it's kind of so if a solvent estate is the assets are greater than or equal to the debts, an insolvent estate would mean the assets are less than the debts of the estate. So we kind of go through a different process, and you're probably saying, David, how do we figure out who we owe? Well, during the probate process, you're going to send out letters to any potential creditors. You're going to place notice in the mail that the person has passed away, in the newspaper. And the thing is, in the state of New Jersey with insolvent estates, they actually have a statute that dictates to the executor how people are to be paid out. Now, what do I mean? It doesn't say, funeral parlor only gets X amount, $1,000. It gives us an order of priority of who gets paid with the assets. So this is kind of broken down, and I'm going to go through this in order. So they start off with, so after you've gone to the court, you've gotten your letters testamentary or your letters of administration. You've collected all the debts that you owe, that are owed by the decedent, and you have all your assets. Now you have to basically present to the court and say, look, we need you to rule the estate insolvent, and here is our order of payment. And it starts off with reasonable funeral expenses. The term reasonable doesn't mean it has to be the cheapest, but you also have to remember it can't be, you can't spend $50,000 on the funeral either. Reasonable. So, kind of like a normal funeral. The costs and expenses of administration. Now, what is this? The executor fee. If the estate had to hire an attorney to handle anything, if there needed to be an accountant to handle any tax issues or accounting purposes, those would kind of be the costs and expenses of the administration of the estate. So those would be number 2 to be paid. Part C, or the third person, would be debts for the reasonable value of services rendered to the decedent by the office of the public guardian for elderly adults. Now, if the decedent passed away and there was no guardian for the elderly adult, you don't have to worry about Part C. If there is, then Part C, and they would probably submit their fee, and you would put that in. D are the debts and taxes with preference under the federal law or the laws of this state. So basically, what does that mean? you got to pay the taxes. So if the decedent owed taxes to the federal government, you pay the federal government, and you got to pay the state government. The next part would be reasonable medical and hospital expenses of the last illness, including any compensation of persons attending him. So if there was an at-home aide, you would have to pay that person. Then it would be judgments entered against the decedent according to the priorities, which basically means if somebody had a judgment against the decedent and it was properly filed, the first person that filed the judgment goes first, so on and so forth. Then it's all other claims, which would be unsecured creditors. So they're basically at the bottom of the pile. And basically what you're doing is you're going to the court and you're saying, look, we only have X amount of dollars. We can only pay in full up to a certain point. The next person, you have to say they've been paid in full with the remainder of the money, or if the estate comes across any other monies, we have to continue to pay that person. Everybody else would get a copy of the order, and basically it says, we're sorry, the estate was deemed insolvent. Here's a copy of the court order, and we can't pay you. And then it becomes their problem. So that's kind of the difference between an insolvent estate versus a solvent estate. Solvent estate's pretty straightforward. You have enough money, you pay everybody, and you can go about your business. Insolvent estates have a priority in which people need to be paid. So I hope you found this video interesting and helpful. If you did, please hit the like button. Please share this. If you know somebody who's going through the probate process and may have questions about insolvent or solvent estates, please share this video with them. Tell them you were thinking about them. If you have any questions pertaining to this topic or any other topic pertaining to, estate planning or probate, please contact me at njestateattorney.com. You can send me an email directly at david@campanilelaw.com or schedule an appointment directly on my calendar. There should be a link above or below. As always, I'm David Campanile, owner of Campanile Law, located in the state of New Jersey. We handle estate planning and probate.